On case number 23-50636, United States versus Ethan Sturgis Day, and we'll begin with Orlando Mondragon for Ethan Day. Yes. Did I get close to your name?
Yes, that's better than most people, Your Honor. Usually, I'm from the Lubbock area, and over there they say Mondragon. Mondragon.
Mondragon. Okay.
Good morning, Your Honors. I'm coming from El Paso, and I was telling the opposing counsel I haven't done an oral argument in about 13 years, so I'm out of practice.
Mm-hmm.
Your Honors, this case, it was I believe a case out of El Paso, about a 3-week trial. And I went through the record, and I guess in talking to my client, the issue is the main issue I'm focusing on is the 6-level enhancement under Guideline 2B1.1. I already looked at the cases that opposing counsel cited, the ones I cited, and I guess the issue is, does the record support the 6-level enhancement? Our position is that it does not, because the trial court made an assumption just based on the loss, the total loss of the victims. And I understand the case law doesn't have to address every single victim, but it's a general assumption that everybody has suffered a substantial loss. I don't believe that applies in this case. Under USB 1.1 B2, it's victim based. It's not loss.
I mean, what more would you think should have been presented?
For example, Judge, I saw Your Honor, on Adinoy, I saw that they provided actual victim impact statement, and that had the actual how it affected the individual, the actual victim. I believe that was a business that lost I don't know how much, $200,000, and they said it didn't bankrupt them, but they weren't able to pay their bills for 6 months, so it kind of met one of the factors listed on the application note 4. In George, I think USB George out of the Ninth Circuit. On that case, again, I think the victims lost $1,000 to $3,000, and I believe the court said that they didn't have to show each individual loss, but even in that case, they addressed how that some had they had I think they went through bankruptcy. Some had a mortgage, had to borrow money, so it's kind of met some of the factors listed on application note 4. I think application note 4 is not exhaustive. I guess it provides guidance, but I think the trial court just says, basically when he sentenced Mr. Day, he says that the fact that they paid so much money and didn't get anything in return, that by itself amounted to substantial hardship. At least that was my understanding on when he made the sentencing. So I just believe that you can't put them all in the same boat. I think you have to have specific individual findings as to how each individual, how it affected them, because as the case law says, it's victim based.
So you're saying if someone was a millionaire and lost $40,000, that would not be substantial?
I guess it depends on how it affected him, Your Honor. For me, it would be substantial, but I guess toward the individual. It's like the case law says. If you have a Bill Gates, a Mark Zuckerberg, I mean, you lose $1 million and they're billionaires, I don't think that'll hurt. But if you have somebody that has maybe...
Right, but for most people, $40,000 is a lot of money.
It is.
And I don't think there's any indication any of these people are billionaires or even millionaires.
That is
so why isn't that enough for what the district court concluded?
Because I think, again, Your Honor, because I think at least on the guidelines, it indicates that, and the case law indicates that it's victim. You have to show how it affects the victim. We're making an assumption that $40,000 affects this individual. I think it affects almost everybody, but each individual is in a different set of income bracket, or I don't know how that. You have to base it off of how much income they have, Your Honor, or financially how are they doing. And right here, I think a bunch of them, a lot of them, I think many of them weren't well economically off. So I think a bunch of them, like somewhere 150,000. So I think it's safe to assume that that's a substantial loss. But there were some that were like 6,000, 14,000. And I think that's already taken into account on another guideline, which is the amount of loss, not how it affects the victim. I think in this case, Your Honor, they had a restitution hearing. They didn't provide any victim impact statements to show how it affected each individual when they had an actual restitution hearing to determine the amount of loss. All we're asking for, Your Honor, is a remand to determine the individuals, how it affected them substantially, what hardship did they suffer. It doesn't have to meet the requirements under 2B1.1, B2, Your Honor, but at least in the case law that I read, many of them did have some of that situation. Some became insolvent, and some lost their savings. In this case, just based on what the court said at the actual sentencing, I think the court went. He said, I believe he said when he did the sentence, 1 or 2 individuals lost their savings, but that's all he said. He didn't say this individual lost that, this individual lost this, or it affected them. It's just the assumption on the amount of loss, because as the court is aware of the amount of money that they paid, and they didn't get anything in return, it's a substantial loss. But that's what I have to say, Your Honor. I think it's victim based. So, and not every victim's in the same boat. We're making the general assumption that, at what amount is it a substantial loss? 10,000, 15,000, 20,000? But I think you have to compare it to the individual, because as the question posed by the court, it's different it's 40,000 is a lot for almost everybody, but each individual is different, and that guideline is victim based. It's not the other guideline takes into the amount of loss addresses the amount of loss. I also did address the role, Your Honor, and the only reason I did that is because the judge at the sentencing court first agreed with minor role, and they had awarded it, and then and when the court made the ruling, initially said that he heard the whole testimony. Burke is the main player, and Mr. Day is at the bottom. But then he rescinded that ruling after, I guess, brief argument from the prosecutor and then meeting with probation. So he rescinded it. So I think the court was having a hard time accepting that whether he was a
legal
manager compared to Burke. I think that's the issue I have with that, Your Honor. And and he didn't articulate, I guess, at the time that he rescinded the minor role, or why did he not make him neutral? Why did he enhance him again? Why did he do that? He didn't articulate, well, you're controlling, you're addressing this and addressing that, or you're engaging in sending these emails, you're bringing these people in. He didn't do any of that. He just said, I remember this from the trial. But that was after conferring with probation and the argument from the prosecutor. And that's the reason we're arguing minor role, Your Honor, because the court didn't articulate not the role enhancement, not minor role. The court didn't articulate why are you rescinding the ruling. But that's what we have on that, Your Honor. But that's all I have on these cases, Your Honor.
Okay.
Thank you, Your Honor.
Thank you. And you have saved time for rebuttal. And we'll now hear from Mark Stelmach for the U.S.
Thank you, Your Honor. I couldn't hear counsel very well. I think my wife might be right. I think I need a hearing aid.
Well, you've read the brief.
Yeah, yes.
Okay.
Yes, Your Honor.
So the bottom line is the question of why didn't the district court take a look at each victim, or at least 25 of the victims, because while nobody wants to lose $40,000, it has maybe a life effect on one person and on another. So, and then the amounts were varied. I'm just using the $40,000 that was discussed, but there's a varied amount. So why wouldn't the district court take a look person by person?
Well, all the leading cases, the 3 cases, George, Minhouse, Howder, they've all rejected the argument that the court's required to make individual findings as to 25 specific victims, and just by the general principle that you can make a reasonable estimate of losses based on the available information. Same is true in counting victims, as long as there's evidence that you can infer a pattern. Now, the court made findings that it started off by saying two of the victims got completely wiped out. The court could have made more findings there, but the victims all testified that the reason they were buying container homes was that they couldn't afford traditional homes. So that's the key. In George, where the victims lost $1,000 to $3,000, they found a pattern. They found substantial hardship because these victims were vulnerable because they were seeking loan assistance. In Menhouse, also involving $2,000 or $3,000 losses, the pattern was found because these victims were using a discount travel service, and the court says, well, they're not using a fancy service. We're generally of modest financial means. So if we're missing the statement that all these people were of modest financial means, it was because it was apparent from everyone who testified that we can't afford this. We can't afford a traditional home. All the victims who testified, Jones, Rao, Wade, Pissarro, and Miller, they said they ran out of money. Rao said he ran out of money. Wade said he ran out of money. Pissarro and her husband said they lost all their money. Cynthia Miller, which the court quoted in the findings, Cynthia Miller was a particularly pathetic character who lost $94,000, and now she is living in a structure in Arizona with no air conditioning, no running water, no electricity. The court highlighted that. He could have gone down the line of each victim, but found but there's a pattern in these it's an easy conclusion that people who are buying shipping containers for tens of thousands of dollars instead of traditional homes for hundreds of thousands of dollars are more modest financial means. And so also, I don't think it was apparent from the briefs, there was a restitution hearing that took place over a considerable period of time. And every single victim was analyzed, but the focus of that analysis was they were trying to get the restitution figure, or the loss figure, down from 1.5 million to save two levels. But the financial statements of each victim, the victim impact statements that were filed were submitted to the court. The court said on the record that I've looked at every single paper that I've received from probation. That's at 10804 of the record. And the victim impact statements, just real briefly, RL, let me start with DT, said, I saved for months for a dream home and my dream was shattered. And this kind of falls in line with the PSR finding, where the probation officer said that they sold the victims a dream. But considering the record as a whole and losing all their payments, the implication is that their financial dream of being a homeowner was shattered by their losses. And that's exactly what DT said in the victim impact statement. That's at Exhibit 24 of all those records in the hearing of August the 9th, the restitution hearing August 9th. NB discussed that the container homes were for low-income people. CG said that they had a dream of building a house, but now they had an empty bank account. That's in Exhibit 28. RC said they lost all hope from losing their money of owning a home. That's in Exhibit 30. And so the court, yes, started down the line saying substantial loss of savings. Some victims were wiped out. Didn't go down the line for all 25, but I think a pattern was readily apparent to the district court that these victims were in the same economic circumstances and that these losses, these are not, in George and in Menhouse, we're talking about doing a big analysis to see if $3,000 or $2,000 is a substantial financial hardship. The court had that exhibit, not exhibit, it's the addendum number 5, supplemental addendum number 5, which lists all the victims, thousands and thousands of dollars. The average loss is $40,000. The median loss is $23,000. So it was, if you're faulting the court for not being more specific, my answer would be it was a 3-week trial. The court looked at every single paper and victim impact statements, and it was readily apparent that that these victims suffered substantial financial hardship. And I think you can also even look at the 5th factor. The 5th factor, the savings factor, is what the court relied on. But the 5th factor is there substantial financial hardship from making substantial changes to living arrangements? Now, most of these victims bought and paid for a container home for tens of thousands of dollars, didn't receive it, lost the entire amount of their money for a home. So my argument would be that's the equivalent of losing a home. There's at least one case, I think, that the Third Circuit case that fell in line with that. It was akin, losing the money for a home was akin to be found to leave a home. I think the savings rationale here, though, was reasonable, it was plausible in light of the record as a whole. These losses were far from insubstantial. And Adder-Inouye and Menhouse said that between a minimal loss or hardship and a devastating loss is a wide range where the judgment of the district court may be relied on. I think this is such a case.
Counsel, there's something in the can you hear me okay?
Yes.
The district court's explanation that troubles me. So the district court says, in essence, say that someone spends 40 grand on one of these, gets nothing, but because it's just savings they had available, they wouldn't qualify as financial hardship. That just flies in the face of common sense, and I'm not buying that. Right. So I guess my question is, how do we evaluate? Suppose, just for the sake of discussion, I think that's wrong. I think that misunderstands application note 4F. That's not the way this works. What's the harm in sending it back to the district court to calculate? I mean, as you point out, this is not like a 20-minute trial, right? It goes on forever. Is there any real harm in sending it to the district court and saying, we haven't really had occasion to develop fully Fifth Circuit precedent on 4F and how this is supposed to work? It's important that district courts understand that when the government is seeking these enhancements, that people calculate the numbers correctly. So please calculate the number correctly.
To take the last part of your question first, I think that's definitely something that could be done. You just have the district court really reiterate what he already knew about the 9 victims that were covered, and then go into the exhibits for the financial impact statements. That could easily be done. What I wanted to make a point, though, about what the court was saying. I think if you go back to what was being argued to the court, the court took it as the argument as saying, hey, you lost $40,000 from savings, but you already had that money. So a loss of that money can't possibly be a substantial financial impact. And the court then kind of said, oh no, that's not true, and then made the statement that you're saying. But if the court could have made more detailed findings as to the number of victims, but how many do you need? I completely disagree with that you need 25, that you have to make a specific finding as to all 25. Once you have a trend, once you have a pattern of people in certain economic circumstances, and these are not rich people, they're not millionaires, they're not even traditional home buyers. They're people trying to buy a home out of steel containers. And so once you have that set up that they're in these troubled economic circumstances or modest economic circumstances, as Minhouse talks about, and George and Minhouse talks about, once you see that all these groups are in this class, then you could look at losses and say this is a pattern of substantial financial harm. I don't have much to say about the manager or supervisor. Day was a co-owner. He set up the primary bank accounts. He signed contracts. He was the named marketing person. He sent fake photographs. He sent false messages. He had a large share of the profits. He managed McMaster as a sales rep in Clayton, but he didn't need to manage. He didn't really need to manage anyone because he managed the property, assets, and activities of the enterprise. And then the main complaint is that Day was the bigger manager, but you can have more than one manager. I think that's all I have. If you don't have any further questions, thank you.
Okay, thank you. And we'll now hear the rebuttal.
Quickly, that's what we're asking for. Because the guideline jumps from 6 victims, I think, 5 or more victims, it gets a 4-level increase. And then there's a big jump from the 5 victims to 25, and it gives you a 2-level increase. And the court was not specific enough to articulate which victims are we using, or this group has this. And that's all we're asking for, is a remand so we can calculate and see how it affected them. And if the evidence does show that there's substantial hardship, then I think the guidelines can be, the sentence, the PSR is correct. But I believe trial counsel has specifically objected to the 25 victims, and the court just made a generalization. So we're basically asking for a remand so the court can consider how it affected each individual victim. Thank you, Your Honors.
All right, thank you. We've now concluded for today, and these cases are under submission. And